So, especially in Europe, my understanding is that each country has their own approach to IP and to litigation around that. What are some of the emerging trends around potential consistency across the different territories in EU?
Yeah, that's absolutely right. The patent rights are national rights.
Yeah.
We have a centralised application system in Europe through the European Patent Office, but when those rights are granted, they take effect as national rights. And that does mean that the patent landscape can be somewhat fragmented across Europe, and it does create an element of complexity, which as patent lawyers we do our best to try and clarify and really utilise to the extent possible. But there's no question that if there were to be a single patent for Europe, a single dispute resolution system, that would certainly simplify the process. And that was, frankly, in the offing. The Unified Patent Court was going to be a single court that would adjudicate on matters of validity infringement relating to unitary patents and also European patents. Following Brexit, it is certainly going to be delayed. It appears that the UK will not participate in that system as it won't be a member of the EU. Although it remains to be seen whether the UPC will continue to go ahead without the UK.
Right.
I should say that the Unified Patent Court set up under an international agreement. The unitary patent right itself derives from the European Union, and the system does require within the agreement referrals to the European Court of Justice, and it was considered that as the UK will not be able to do that, having left the EU, that it could be difficult politically for the UK to continue to be in a system which is effectively still is arguably subservient to the European Court of Justice. And I've just one final thing on the European aspect. The UK is a member of the European Patent Convention, a treaty system completely separate to the EU. As we understand it at the moment, the UK will continue to be a member of the European Patent Convention even after Brexit. There's some discussion at the moment as to whether that may be affected, but as I understand it, at least for now, hopefully the UK will continue to remain part of that very important international patent treaty.
But it sounds like at least for the short term, there will still be differences in the country specifics for handling IP within Europe.
That's correct, yes. I think it's fair to say that the Unified Patent Court will not be coming into effect anytime soon, and equally the unitary patent will not be coming into effect anytime soon either, and that does mean that patents will continue to take effect on a national basis, and patent disputes will require resolution again on a national basis.
Right. Are there certain territories that are either more favourable or less favourable as you go into patent disputes? And I guess it depends on which side of the table you're at.
Yes, it does depend on the circumstances. Certainly as a patent owner, it was and is considered that Germany is a particularly favourable jurisdiction, partly because in Germany they have a bifurcated system whereby patent infringement and patent validity are considered by two separate court systems. So from a patent owner's perspective, it's possible to sue for patent infringement in Germany, to get to trial, to have a decision on infringement and potentially an injunction awarded without the validity of the patent having been considered. Now, from a patent owner's perspective, that is very attractive, and it can lead to early settlements of disputes. The prospect of obtaining an injunction may be enough to bring the other side to the table to resolve it by way of a license. Equally, there are many advantages in, for example, the courts of the Netherlands recently introduced an accelerated patent litigation system which operates very quickly. I was involved in a case that went to trial in the Netherlands in just over 9 months, incredibly quick. The UK is also pretty fast at the moment, operating about a year or so, and maybe a year to 18 months for an appeal. So there are different timelines involved across Europe, and there are different factors to take into account. As I mentioned, Germany, UK has a very attractive cost position for the winning party. There's also the factors of disclosure. You can find out information from the other side as to alleged infringing acts, cross-examination of experts, cost regimes. So it is a multi-factor assessment. But yes, there are certain jurisdictions that I would say are the key patent jurisdictions, and certainly if you're able to obtain one or two favourable decisions from those courts, then that can be very persuasive in the other European courts. So to essentially present those judgments to other European courts to say, you know, look at what the English court has decided, look at what the German court has decided.
Yeah.
And that can be quite effective.
Understood.